Well, welcome everyone. I'm Jim Spiewak again, your host here on this YouTube Live. We are streaming on all of our digital platforms as well. I'm with KUTV, and we have closed, I shouldn't say closing arguments, I should say both sides in the Kouri Richins case have rested their case. Prosecution rested today, and then the defense, without calling any witnesses, they decided to rest as well. So we are here to break down everything that happened today. We're going to talk about everything that happened in the trial up to the very beginning or up to today. And to help us do that, we once again have Nathan Evershed joining us live in person today. We usually talk to Nathan over Zoom. Nathan, thank you very much for taking some time to come here to our 2 News studios and talk with us in person. We really do appreciate it.
Glad to be here. Thank you.
Absolutely. Okay, so bit of a curveball, I would say, today, where we knew pretty much that the prosecution was going to be ending. What we didn't really know is that what the defense was going to do. And we found out very quickly that the defense didn't want to call any witnesses, and Kouri didn't end up taking the stand. I think even the judge, which we're going to see a little bit, was maybe a little taken aback by that. Not taken aback, but just I think we were all expecting something from the defense, and we got nothing. What was your takeaway from court today?
Yeah, that was really interesting. I don't think most people were expecting that to happen. After all, this was set for 5 weeks, and we're ending now the 3rd week.
Yeah, right.
So I think people were anticipating the defense to present evidence, and they decided not to, and that was quite a surprise for probably most people in that courtroom, and a surprise for me as well.
Yeah, so let's kind of dive right into what happened today. So the day started with the defense attorney, the defense attorney is doing cross-examination on Detective Driscoll. He was the lead investigator in this case. Not a ton really came out of that. Just sort of the defense was continuing their cross-examination of that particular witness, and then he was released from his subpoena. And after that, the defense ended the prosecution rested their case. Immediately after that, the defense made a motion to dismiss. And I do want to play that exchange right now. So there was a motion to dismiss, and then the judge's ruling on that. So I'm going to go ahead and play those 2 pieces right here, and then we'll talk about it. So here's that first piece.
It is the position of the defense that some evidence exists from which a reasonable jury could find that some, however, not all of the elements of the crimes that have been proven beyond a reasonable doubt.
Okay, so is it a directed verdict? Is that what it's called? So the defense asked for a directed verdict. What is that?
It's very rarely granted. It is something that is expected for the defense to make, otherwise they could be found ineffective, and they don't want to be found ineffective.
Yeah.
So it's essentially an argument that just says there's not enough for the jury to even base a conviction upon with this evidence, even viewed in the light most favorable to the state. So they're arguing that there isn't sufficient evidence that's there. It's a directed verdict motion. Therefore, dismiss this case or dismiss some of these counts, and that's what they're arguing for.
Gotcha. Okay, so then right after that, didn't take long for the judge to go ahead and make his ruling on that.
The court finds that the state has established a prima facie case against defendant Kouri Richins by producing believable evidence of each element of each crime charged in the operative information. Defendant's motion for directed verdict is respectfully denied.
Respectfully denied. So pretty standard stuff right there.
Pretty standard stuff, and the judge laid out what the law is, which is totally expected. This judge has been laying out what the law is and what the rules are this entire trial. Been doing, I think, a fantastic job. And so he just lays it out and says, there is evidence that the jury can look at to make a determination that, yes, these elements have been established. Now, he's not saying that they are going to do that. He's not saying that they should do that. He's just saying that they could do that.
Right. And yeah, like you mentioned right there, he did use that exact word, could.
Correct.
The could being the opportune word there. Okay, so then what seemed like a bit maybe of a surprise to everyone in the courtroom, maybe not those that were sitting at the defense table, the defense, they came back from a lunch break, and right after that, they decided to rest their case. And so I want to play that clip right there because you can kind of start to see people's heads in the courtroom kind of look around and be like, okay, is this really happening? No witnesses are being called. So I'm going to go ahead and play that right now. This is the defense saying that they are resting their case.
Your Honor, actually at this time, the defense intends to rest.
We should probably do that in front of the jury, yes?
Right?
Okay.
I agree.
I just want to make sure you've consulted with your client about this.
Absolutely.
is now an appropriate time to get a waiver of Ms. Richins' right to testify on the record?
Yes. Yes, you can.
Okay. You've consulted with Ms. Richins about her, or advised Ms. Richins about her right to testify, correct?
At length.
Okay. Ms. Richins, may I ask you 2 direct questions?
Yes.
Do you understand that you have the right to testify at trial?
Yes, I do.
Are you following your attorney's advice and waiving your right to testify at trial?
Yes, I am.
I accept your waiver. I find it's knowing and voluntary.
Yeah.
Okay, thank you.
So there we heard from Kouri Richins saying, yes, I do, and yes, I am, responding to the judge there. That's all we're going to hear from her in this trial. Your thoughts there that the defense doesn't want to really mount a defense. They're resting.
They will be arguing in their closing argument that we don't need to make a case. We have nothing to prove. It is solely upon the prosecution to prove this beyond a reasonable doubt. We feel like they have not done that. Therefore, we don't even need to call witnesses because we feel like based off of what the state has already presented, there's not enough there to convict our client. You'll be seeing an argument like that.
And does that, I have to imagine that that decision is made between the attorneys and the client ultimately, as the trial is going on. Like, that's not something that they're going to determine probably before the trial even begins. They need to see everything and how it plays out. So could we guess or assume that that decision was maybe made today or recently, that they weren't going to call any witnesses?
It's possible.
Yeah.
I think beforehand, they probably had a really good idea of whether they're going to put their client on the stand, at the beginning of the case or not. Because if you're going to be making that decision, you're going to prep her, you're going to, have things getting going on that case. So they probably made that decision a while ago. But in terms of other evidence that they may have wanted to present, for all we know, maybe they feel like they already got it out through their own cross-examination, and so therefore they don't have to put on their own witness. Now, the other reason why they would also not put on their own case in chief is not just because they feel like the prosecution hasn't proven it, but they're also trying to do no harm. There's a risk that if they put on evidence, if they call certain individuals or talk about this part of the investigation or get into other things that Ms. Richins may have said, now the prosecution can now really exploit that. So now you put on this evidence, you've called some witnesses, and now you've just made the prosecution case, the prosecution's case better because you've now done this. And so I think it's probably that dual idea, which is one, we feel like we can already make the arguments that we need to because the evidence that we needed to get out is out now. But then two, we don't want to do any more harm to our client or to our case because there's so much risk by putting on witnesses anyway.
Do you think it would be a risk to put a client on the stand? I mean, it's always a risk, but do you think it would be a risk to put Kouri on the stand?
Absolutely. I am not surprised in the least they did not put her on the stand. There are so many problems with that, not least of which there's a judgmental factor of people who may really like her or maybe just don't like her.
Yeah.
And you just don't know that. I mean, how can you even judge that?
Sure.
And then two, by putting her up on the stand, you can just it's called opening the door. She says something and all of a sudden the stuff that you're trying to keep out, now that's coming in with abundance. And then three, you're making the prosecution's case. They pretty much get to do two closing arguments. One, through this defendant.
Yeah.
And then two, when it comes to closing argument.
Yeah.
And so it's just way too risky. I'm not surprised in the least that she did not testify.
So we're going to get to closing arguments on Monday. The jury is going to be out until 8:30 Monday morning. And I guess before I ask that next question, let's go ahead and play that piece of sound because the judge was very specific and asked both sides, are we good if we recess until Monday? It's Thursday. If we recess until Monday, is everyone good with that? So I'm going to go ahead and play that piece of sound right now.
You were thinking it might make sense to get the jury instruction conference out of the way and then...
I agree with you. May we do it tomorrow? Give the counsel both sides a chance to talk to each other about any additional instructions you think might be necessary, narrow any differences or discuss any differences you have regarding any of those, and we can have that conference tomorrow.
Yeah, yes, that's right.
Okay. So we'll talk about scheduling about that. Just want to make sure we're all comfortable with the jury being out in the wild between now and Monday morning, yes?
Yes.
Yes, sir.
Okay. Okay. All right. Are we ready for the jury? Mr. Bloodworth?
Yes, sir.
Ms. Lewis?
Yes, sir.
Okay.
So then the jury got brought back in, and they both sides said we're closing or we're resting, and then the judge said you're dismissed. But I thought it was interesting there, that last little piece where he was like, okay, he was almost like triple checking to make sure that everything was done, everyone was done saying what they needed to say on the record.
Right. You could just see the wheels spinning. Right?
Yeah.
I don't think that the judge anticipated for the defense to rest. Maybe he did. But now he's considering, what do we do with this jury? Everything's now in. Do we sequester them? Do we just trust them to go home or out into the wild until,
Right.
in his words?
Right.
So we just kind of thinking through all of these potential ramifications.
Right.
But when both sides say, we're good with them just coming back at 8:30, he's thinking through that. Okay, that's all you can do.
Yeah. I mean, as an attorney on both sides, do you think they said they were okay with it, but there maybe is a risk that they turn on the news or watch a podcast on this?
I think there are two things. One, in my experience, jurors have been so faithful to being right.
Okay.
And but then on the other hand, this is unlike any case that we've really had in Utah.
There's so much exposure.
There's so much exposure
Yeah.
that's here as well.
You almost have to go out of the way to not have this hit you in the face.
Correct. And so I think there's that balanced approach of like, should we at least sequester in this kind of instance? Now, I would tell you that is so far remote of an idea or of an experience that's happened here in Utah. I don't even know the last time a jury's been sequestered in Utah. So it's just not something we do. We just rely on the credibility and
Yeah.
the will of people.
Yeah.
They've been following that through, and we expect them to follow that through.
So when we get to 8:30 on Monday morning, we're expecting jury instructions to be laid out, and then it's presumed that the jury will start deliberating.
Yeah.
But before that, there will also be closing arguments. Can closing arguments be looked at as maybe sort of the opinion of each side, as both sides try to say to the jury one final time, here is our opinion of what we think happened based on the facts that were either laid out or the facts that weren't laid out beyond a reasonable doubt? So can it kind of put that final exclamation point on the jury as more of, opinion might not be the right word because they're still talking in fact, but can closing arguments be a little different in that respect than the rest of the trial?
100%. Yeah, it's arguments. Whereas the opening statement was more of a statement. This is what to
Yeah.
expect. This is now argument. And you watch, I think it's going to be robust. I think
Yeah.
Both sides have really been probably eager to be stating their arguments. And it's going to be long. It's probably going to take all day Monday.
Yeah.
And there's just a lot to cover. I think that they mentioned today that about 45 witnesses have testified. I don't know how many, hundreds of exhibits,
Yeah.
videos, text messages, and all of these things. So you watch for them to come in and just say their arguments. Like, why do these witnesses matter? Why does these specific pieces of evidence matter? These exhibits matter? The jury's going to get an instruction saying what the attorneys say during closing argument is not evidence.
Yeah.
You are to base your verdict on evidence. Now they're making arguments and they're trying to show their narrative, their side of the story. But it's going to be really fascinating to see how they do that.
And in your experience, is there anything to make of the fact that the defense did not call any witnesses in terms of acquittals? I don't know if there's been any studies done on that or any sort of empirical research, but again, it's a strategy.
It is a strategy, and it's not unheard of. I
Right.
mean, and it's when you kind of go back and go through what the defense has been arguing, it's not that surprising in a sense. I mean, having said that, I was surprised when I initially heard this, but then you begin to think their whole strategy has been there's just not enough from the state, and they're going to continue to go through that. And so, so what this does is it kind of leans into their theory and their argument, and of saying, listen, we didn't have to present any evidence because there's not even enough for you from the state side. So it does kind of bolster their whole theory that they've been laying out for 3 weeks that, hey, listen, what they have is not even enough. And that's what they're going to be arguing.
You think they'll be arguing this is all circumstantial, number one. Number two, the state did not prove that Kouri gave Eric fentanyl.
Correct.
And is that kind of the beyond reasonable doubt portion that you think they may hammer home?
Yes, they're going to say, where's the fentanyl? Where's the bottle? Where's the evidence that she did this? How was this even administered? Nobody can tell you exactly what time this happened. Nobody can tell you how this happened. Nobody can tell you how this was administered or when. Nobody, found fentanyl in the home. All of this stuff. And so the key things like the smoking gun, ladies and gentlemen of the jury, is not here. And if you're going to prove my client guilty beyond a reasonable doubt, well, I tell you what, you need something more than just hyperbole and then just these things that are trying to connect the dots.
On the flip side, people have been convicted on circumstantial evidence
Correct.
alone, have they not?
And the one thing that this case is not lacking is evidence.
Right.
Okay, and that is something for the prosecution. So what I just did was just try to lay out what the defense's argument will likely be. The prosecution's is going to be, I mean, I was thinking about this. It seems like everything comes in two in this case. It wasn't one poisoning, alleged poisoning. There's two of them.
Right.
It's not one drug dealer that they got to have testify. It was two of them. It was not one just walk the dog letter, but there was also a journal that was also there. I mean, it just seems like it wasn't just one web search, but there were many. It wasn't just one text message, but there were many, like all of this stuff. And what they're going to say is that they're going to point to the jury instruction that will just say, you can convict someone based on circumstantial evidence.
So that'll be part of jury instructions.
That will be part of jury instructions.
Yeah.
You can find someone guilty based solely even on circumstantial evidence.
Right.
And you can see why is that if you couldn't prove a case just based off of direct evidence, and there's a lot of cases that would not be proven.
Correct,
So
yeah.
hypothetically, and she hasn't been convicted of anything
Right.
yet, hypothetically, if she did poison her husband, you can understand that would be easy to destroy evidence and to hide evidence.
Yeah.
And that's, I mean, how else would you prove? That would have to be, of necessity, a circumstantial case in almost any regard. And so circumstantial evidence is still sufficient evidence, but what the jury has to do is that they have to find it beyond a reasonable doubt, meaning that they're firmly convinced.
And that's a high standard.
It's a high standard. It's
By
the
design.
highest standard. Yeah, under law, it's the highest standard. It's way above, clear and convincing evidence, or way above,
Yep.
anything else. So it's by design because she is looking at the rest of her life
Right.
in prison.
Right.
And so, in order to do that, what you're going to see the defense saying, how can anybody be firmly convinced about this kind of evidence when you don't really even have the smoking gun and everything, and it wasn't investigated properly, et cetera, et cetera. And then the prosecution, no doubt, is going to be saying, well, what, is everything just a coincidence?
Right.
The drug buys, the cell towers, the text messages, the cell phone searches, the walk the dog letter, all of these things, all of this is just a coincidence and it means nothing.
Right.
And they're also going to be arguing, you watch that, well, then how did he die? And they kind of said this in the opening statement by saying, there's no evidence that he was suicidal, and there's no evidence that he was even taking drugs, essentially. They're going to be their argument. I'm sure the defense is going to say
Right.
different things. So if he wasn't suicidal, and this wasn't accidental, then he was poisoned. Why would he be poisoned? Well, you look at all this motive evidence that comes out, and you can understand the complexity of this case because it's all circumstantial. There's so many layers.
There are so many layers.
And at the core of it is just this tragedy that's alleged.
Right, absolutely. And so jury will deliberate. Obviously, we don't know how long that will take. Typically, will they just let them go all day? And then if they don't reach a verdict, go home for the night, maybe come back the next day. And it has to be all jurors have to unanimously agree, correct?
5 counts, each of those counts has multiple elements,
Yep.
and all the jurors have to unanimously find that each of those elements were proven beyond a reasonable doubt for a single count to be entered.
Yeah.
So they can split charges, they can say guilty on some, not
Right.
guilty on others,
Yeah.
or whatnot. And they have so much evidence that I would expect the deliberation to be pretty thorough.
Yeah.
But maybe we get a verdict as soon as Tuesday.
Yeah.
Or maybe it's going to take some days.
We just don't know.
And I'm guessing that they're not complaining too much. They think that 5 weeks of their life that was going to be suspended in
Right.
time, now
Right.
it's been cut short, and now it's only closings left and deliberations.
So we got through the trial proceedings. Again, the jury is expected to start deliberating after closing arguments on Monday of next week. Let's kind of take a step back and look at this case 30,000-foot level from the 3 weeks that we've had at trial. And I know we've been talking about it for the last 3 weeks, but as we sit here right now, what really just the couple things that really stand out to you? I know you said that things have kind of come in twos.
Right.
We've talked about the defense deciding not to call any witnesses, including Kouri. Anything else that has really kind of stuck out to you during the course of this trial?
It's
I know it's so much to think about.
there is so much to think about.
There really is.
So I was a prosecutor for 11 years and did a lot of homicides. And in a case like this, you really have to show to the jury how something happened, okay? And so much of that case was built upon, well, how this could have happened.
The how.
The how.
You've talked about the how a lot.
Correct. And
Yeah.
so I think that there's a lot of evidence to show their theory, at least, that like this is how it all happened. You know, prenuptial agreements tied in, couldn't divorce her husband, you know, life insurance, the estate, a death is probably the only way out. There's a boy, and then all this stuff. And then you get to the why, and it seems like there's a lot of evidence. Now, it just comes down to how the jury then perceives it. So,
Right.
So for example, everybody can make their own determinations on small pieces of evidence or big pieces of evidence, but I could just go back to those twos.
Yeah,
Like, you know
the
what?
twos.
It would have been tough for the prosecution to prove this case without Carmen Lauber, who was the housekeeper.
She's the star witness, is she
Star
not?
witness, if the jury believes Carmen Lauber is credible, there's no way Kouri Richins is found not guilty. No way.
And the defense did bring up, you know, the detectives were the first ones to say
Correct.
the word fentanyl. She is testifying under immunity, multiple
Right.
layers of immunity for charges that she was facing. So she is not, in the eyes of many, a perfect witness
No, she's not.
for
And-
several reasons.
Correct. When I was a prosecutor, what I would say is like, well, the prosecution didn't choose the witnesses, the defendant did. You know what I
Yeah.
mean? So it's,
Yeah.
And then they had this whole interview of her coming in, and it's just, yeah, there's a lot that's there that the jury can look at, that one witness. And this is what makes it difficult to predict exactly how the jury's going to go, because there's a lot there for the jury to make a determination that, you know what, we just don't find her credible. Or there's a lot that's there where they can just say, you know what, we found her actually authentic, and we found her credible, and we found that the evidence corroborated what she had to say.
Right.
I wouldn't be surprised in the least with either way, because it's just humans making this own
Right.
determination.
Right.
And you can see what the arguments are on both sides.
And we're talking with members of the public and, you know, sort of asking their opinion as they're following along in this case. And I've been talking with people that have been saying, you know, I thought one way and now I'm thinking another way as the trial has been going on. And I guess as we talked about in the very beginning, we just won't know until the verdict is read.
Correct.
And those 12 jurors will have a decision to make now that everything is done in terms of the trial, and they'll go to the deliberation phase here at the beginning of next week. So
Yep.
we will find out.
Yeah, and what I would just say is that the prosecution did their job of putting forth evidence and witnesses. The defense did their job in terms of going to and finding the issues in the prosecution's case. The judge really did a great, I thought.
You're
great
impressed by the
job.
judge.
Oh, very impressive.
Yeah.
As I was saying earlier, I think if there could be some kind of voice changes that people could get. A lot of men would like to have his
I know,
voice.
right? Yeah,
You know.
be included.
Me
Be included.
too.
I
just
mean,
think
yeah.
it's just like he was born for this in a sense.
He really was. But he's had, you know, and I'm not a legal mind, but just in my observation, he's had a great control
Yes.
over his court.
Yeah, I think
and this
anybody's
entire
seen that.
trial. And I think he has been fair to both sides, very fair, very impartial, to lay out a fair case for both sides.
Yeah, and then from the legal side, and I've been really interested to see how he's weighing on these rules of evidence, and his understanding, his thoroughness of going through all of these things has just been impeccable. It really has been.
Yeah.
So it's been fun to see these attorneys. They're doing the best that they can.
Yeah.
They're doing the jobs that they can. It's going to be interesting to see their closing arguments. But at the end of the day, so I think some members of the general public can just give outsized, I guess, understanding or belief as to like it's the attorneys that really control things. In my judgment, it's really been evidence.
Yeah.
It's really been evidence and witnesses. I mean, these attorneys are doing what they can, but at the end of the day, it's whether the jury understand and follow the evidence and whether they find these witnesses to be credible. That's going to be the most important part.
And that's how the system is designed
Correct.
to operate.
Exactly right.
Okay, Nathan Evershed, thank you again very much. We'll leave it right there for now. So just logistically speaking, the jury will not be coming back to court tomorrow, but the attorneys are going to be meeting with the judge on both sides. And my understanding of it is that they're going to get together, they're going to go over the final jury instructions, make sure that both sides feel that it's fair, and that's what will be ultimately read to the jury, that when they come back at 8:30 Monday morning next week, they will be read jury instructions, or they'll closing arguments, jury instructions, and then they will start deliberating. So we want to thank everyone again for following along on all of our streaming platforms. If you're on our YouTube page right now, you can go ahead and like and subscribe, and you will get all of these updates as soon as we post them. So Kouri Richins, trial is now at least the cases that have been made by both sides. They have rested. Jury will come back on Monday at 8:30 in the morning to get jury instructions, closing arguments, and then start deliberating. I'm Jim Spiewak with KUTV. Thank you again, everybody, for following along. We will keep you posted as this trial continues.